Thought my husband was a demon and he was stealing souls. And I said, Noah, what? And that's all I got out. And he shot my husband in the head.
Dastardly deeds. $6. $6, and you just 3 lives were taken that night for $6.
That the move wasn't finished. What was your understanding of that statement?
The person that was supposed to be in Shiesty wasn't dead.
In September 2023, a quiet evening inside a Georgetown, Ohio, home turned into a nightmare when 25-year-old Noah Clifton ambushed his own family. While his grandparents, Ralph and Margaret Neff, and cousin Zachary sat watching TV, Clifton entered the room and, without warning, shot his grandfather, then turned the weapon on his grandmother and cousin. Ralph Neff died at the scene, while Margaret and Zachary survived but suffered severe injuries. Margaret spent months in and out of the hospital and missed her husband's funeral, while Zachary needed extensive facial reconstruction.
He said something to the effect of, if you come outside, I'll finish the job.
Investigators quickly determined Clifton was the only person in the house that night, and disturbing details emerged that he had called his grandfather a demon stealing souls, influenced by his untreated schizophrenia.
Thought my husband was a demon and he was stealing souls. And he never liked him after.
When the case went to trial in early 2025, surviving family members testified through tears, recounting how a once close grandson turned on them in their own living room.
Do you know how many times were you shot?
He shot at me twice. Hands like this. And I said, Noah, what? And that's all I got out. And he shot my husband in the head.
In court, Clifton repeatedly disrupted proceedings, demanding to fire his lawyers and even challenging the judge's right to oversee his trial, all of which were denied.
You should not be my judge for this trial, for this case. You're a rule. You have a rule? I take it up with the legislative branch. I do not want to lawyer.
Despite his outbursts, the evidence was overwhelming.
Judge, I'm bonded today. No, we bonded out today.
A jury found him guilty of murder, attempted murder, and felonious assault. He was sentenced to life in prison with the possibility of parole after 53 years, as the family who once loved him mourned the grandfather they lost and the deep scars they will carry forever. In February 2014, Phillip Ham made a chilling confession when he called 911 from his Union Township apartment, telling dispatchers he had his 20-year-old roommate, Megan Fambry, to death. Ham claimed he didn't fully understand what drove him to attack her and said he barely remembered the moments after the killing. Investigators later determined that the attack included sexual assault, and Ham was quickly arrested and indicted on charges of aggravated murder, and rape. As he sat in the Clermont County Jail awaiting trial, both his family and Megan's braced for what promised to be a painful courtroom battle.
How do you wish to plead? Guilty, Your Honor.
Ham stunned the court by changing his plea to guilty for aggravated murder, sparing both families the agony of reliving Megan's final moments in a trial.
Nothing can bring her back, but like I said, I can't dwell on it and I can't let it define me, and somehow I have to find closure and put it behind me. I still have a son to be here for. I didn't want to hear her last moments. I don't need to hear that. I don't need to hear it in great detail. Any good defense attorney would drag a victim through the mud. I did not want to see that done to my daughter.
Oh yeah, the trial process could have been very devastating and crippling to our family.
In court, Megan's family said no sentence could ever truly measure up to the loss they'd suffered. But avoiding a public trial offered some small relief.
Phillip Ham not only killed Megan Fambry, but he killed me too. He killed a part of my heart, but I don't think that there's a sentence long enough, hard enough, or painful enough.
Ham, only 21 at the time, apologized in tears, saying he wished he could take it all back, words that could do little to heal the heartbreak, but closed a painful chapter for everyone left behind. In exchange for his plea, prosecutors dropped the additional charges of murder and rape. The judge sentenced Ham to life in prison with the possibility of parole after 25 years. In May 2012, Michelle Mockbee, a respected payroll supervisor at Thermo Fisher Scientific in Florence, Kentucky, arrived at work early one morning and never made it home. She was found brutally beaten to death on a mezzanine inside the warehouse. Suspicion soon turned to David Dooley, a maintenance worker at the same facility, whose behavior after Michelle's death struck many as unusual. Investigators pointed to gaps in his story and his unexplained movements that morning.
You will also hear about the defendant's odd behavior in the hours and days following the murder of Michelle Mockbee. Things so far out of character that every person at Thermo Fisher Scientific noticed things about him that stuck out like a sore thumb.
The evidence will not show that when his truck was searched that morning, that any sign of was found inside.
Though there was no physical evidence, no DNA, no weapon, prosecutors argued that Dooley's odd conduct and a possible motive tied to him falsifying time cards were enough to charge him with murder and evidence tampering. Dooley was convicted in 2014 and sentenced to life in prison. But years later, his conviction was thrown out when it was revealed that potentially helpful surveillance footage hadn't been shared with the defense. In 2019, he faced a second trial where prosecutors again leaned on circumstantial evidence and the claim that Michelle may have uncovered Dooley's time card fraud. This time, after about 6 hours of deliberation, the jury found him guilty once more, sentencing him to 43 years behind bars. On the night of August 18th, 2022, 60-year-old Virgil Stewart was making his way home from work across the 15th Street Bridge in Covington, Kentucky, when he was ambushed in what police say was a planned robbery. Stewart, known for his warmth and daily messages to friends, had only $6 in his pocket when he was shot and killed.
One of the most blatant, dastardly deeds. $6. $6, and you just... 3 lives were taken that night for $6.
The senseless murder devastated his close friends and neighbors, who remembered him as one of the kindest people in the community, someone whose simple routines and greetings had quietly brightened their days.
Every morning I would wake up, and at some point during the day there would be a little Facebook message from Virgil saying, "What's up, dog?" We became like brothers. Seriously, he was one of my favorite people here. Yeah, a piece of my heart went with him that night. It really did.
In the weeks that followed, surveillance footage and witness tips led police to arrest 31-year-old LaToya Dale, who admitted she was involved but claimed her accomplice, Zachary Holden, fired the fatal shot.
Ms. Dale told police that her accomplice was the one that pulled the trigger. Whether or not that is in fact true is something that police continue to investigate.
Dale later pleaded guilty to facilitation of murder and robbery and was sentenced to 20 years in prison. Holden, identified as the shooter, received a life sentence plus 20 years with no chance of parole. A third accomplice, Brooke Shepard, was also convicted for helping plan the robbery and given 10 years behind bars.
To not see him come by in the morning, he's there, but I'm not gonna get the "what's up, dog," you know, in those little moments. The loss and the grief, and yeah, he'll be missed. He will, definitely.
For Stewart's friends and family, the verdicts brought some measure of justice, though the heartbreak lingers for a man whose life was cut short over a few dollars and a senseless plan that destroyed 3 lives along with his own. In early 2021, Carl Godfrey was accused of masterminding a deadly murder-for-hire scheme that spread fear across Cincinnati. Between late January and February, prosecutors say Godfrey recruited a small crew, including Mario Gordon and even a boy, to carry out a series of contract killings meant to settle scores and make money. On February 16th, Gordon and the boy joined Godfrey to ambush a man in Westwood. They spotted the target inside an SUV, but when the car began to drive off, Gordon and the others opened fire, Deontay Otis, who wasn't even the intended victim, and injuring others. Just days later, another victim, Donald Steele, was shot and killed in Millvale, allegedly on Godfrey's orders. At trial in 2024, Gordon testified against Godfrey, telling jurors he agreed to help with what he thought was just a robbery, but got caught up in a shooting because he didn't want to look suspicious backing out.
Did I promise you anything? Did Mr. Goodyear promise you anything in exchange for your testimony today?
No, ma'am.
What did you think you were going to do with Shiesty when you got to the location?
I thought it was a robbery.
Why did you do that?
At this point, I really don't know. I can't tell you why I did it, but I did it. They start shooting, so I'm like, I guess I gotta start shooting too. I ain't want to be the oddball that stood out like, oh, brother didn't shoot.
Gordon described how, even after the main target survived, Godfrey insisted the move wasn't finished.
When Carl Godfrey said, that the move wasn't finished. What was your understanding of that statement?
Person that we supposed to be in Shiesty wasn't dead.
The jury heard from other witnesses too, including a surviving victim who described watching her boyfriend die.
So if you never would have gotten caught, you wouldn't be here today testifying then, would you?
No, sir.
So you're only here today because you got caught, right? And you didn't see him give any instructions to shoot anybody or even to rob anybody. Is that correct?
Despite the defense's claim that Gordon was only trying to save himself, the jury sided with prosecutors, finding Godfrey guilty on multiple counts of murder and assault. He was sentenced to life in prison without parole. In April 2016, Paris Hummons, a 19-year-old Wright State University sophomore, came to Cincinnati for what should have been an ordinary weekend visiting a friend. She never knew that Robert Carpenter, angry over a fight earlier that day, was roaming the neighborhood with John Sanders looking for revenge. When Carpenter spotted a car he thought belonged to the man he'd fought with, he didn't pause to make sure. He simply opened fire. Inside were Paris and her friend, who had no connection at all to Carpenter's feud. Paris was and later died at the hospital, while her friend survived the terrifying, senseless attack.
Was going to go out, go shopping, go out and have a good time. We thought the sun rose and shined in her, but you gave her a sunset way too soon.
Police quickly pieced together what had happened and arrested both Carpenter and Sanders, charging them with murder.
I wasn't thinking rationally. It was a bad decision, a bad choice.
Nearly a year later, Paris's grieving family sat in a Hamilton County courtroom and watched the two men plead guilty.
Took my joy that night. When you put the in her head, you put the in our hearts, because we will never recover. You have crushed my family.
She could have came up with something to save somebody's life.
My niece is gone. You know, we unfortunately, whatever she was going to do, we'll never know.
Carpenter was sentenced to 28 years to life, Sanders to 20 years to life, justice by the letter of the law, but a poor replacement for the bright future they stole. Paris, who volunteered in hospitals and dreamed of a career saving lives, was remembered by her family as their hope and light, gone forever because of a single reckless decision aimed at the wrong car on the wrong night. In late October 2012, Barbara Howe, an 87-year-old resident of the Mount Pleasant retirement community in Monroe, Ohio, vanished without a trace. Just days later, her body was discovered. Investigators learned she had been targeted by Daniel French, a former maintenance worker who posed as a repairman, claiming there was a problem with residents' emergency alert systems. Under this false pretense, French gained entry to Barbara's home and killed her. The brutal murder shocked the community and launched a lengthy investigation centered on missing jewelry and the methodical staging of the crime. After more than 2 years of painstaking detective work, a Butler County grand jury indicted French in December 2014. He was arrested at his sister's house in Kentucky and extradited back to Ohio to face charges including aggravated murder and abuse of a corpse. In court, prosecutors described him as a calculating con man who was possibly testing the waters for more killings. Despite his lawyer's attempts to negotiate a plea, the case went to trial. French's taped confession was played for the jury, leaving little doubt of his guilt. In the end, Daniel French was convicted and sentenced to life in prison without parole, finally bringing a grim sense of closure to Barbara Howe's family and community. In April 2013, a quiet neighborhood in Valley Springs, California, was shaken when Leila Fowler was found dead in her home. Her older brother, Isaiah Fowler, had called 911, claiming an intruder had broken in and attacked his sister while he hid. The shocking story sparked an intense manhunt and drew national attention as deputies searched the area and questioned neighbors. But as weeks passed with no trace of an intruder, suspicions turned inward. Eventually, inconsistencies in Isaiah's story led investigators to arrest him, accusing the boy of killing Leila while their parents were out at a Little League game. Isaiah was charged with second-degree murder and taken into juvenile custody, where he continued school while awaiting trial.
It is our position that this is the most reasonable approach to the case with regard to risk and all kinds of other considerations, as well as the age of this particular defendant.
In 2015, he was found guilty and sentenced to serve time in a juvenile facility until his early 20s. However, in 2018, an appeals court overturned the conviction, ruling that parts of his police interrogation were improperly obtained and should not have been used. The decision sent the case back to juvenile court, leaving the tragic mystery of Leila Fowler's death unresolved, and her family caught between grief and lingering questions about what really happened in their home that afternoon. In November 2016, 89-year-old Otto Stewart was found dead inside his Northside Cincinnati home, weeks after he was brutally murdered in what prosecutors called a cold and calculated attack. Investigators revealed that Michael Stumpf and Margaret Kinney had targeted Stewart, tying him up inside his Virginia Avenue house before killing him. After taking his life, they stole his car, money, and belongings, leaving neighbors stunned at the loss of a man remembered for his kindness and quiet presence in the community. Police eventually tracked down Kinney in Lexington and Stumpf in Kentucky on a probation violation, bringing both back to Hamilton County to face charges of aggravated murder and robbery. Prosecutors initially sought the death penalty, calling the murder premeditated and heinous. In 2019, however, Stumpf avoided a possible death sentence by pleading guilty to aggravated murder and accepting life in prison without parole. Kinney also pleaded guilty and received the same fate. In October 2010, David Chandler was shot while sitting in his car in Cincinnati, gravely wounded but still conscious. As doctors fought to keep him alive, police rushed to get answers while they still could. In his hospital bed, Chandler agreed to communicate by blinking 3 times for yes and twice for no. When detectives showed him a photo of Ricardo Woods and asked if Woods was the man who shot him, Chandler blinked 3 times, confirming Woods as his attacker. He repeated this silent identification when asked additional questions about his shooter's nickname, signaling to officers with his last bit of strength the identity of the man who left him dying. Nearly 3 years later, Woods went on trial for Chandler's murder. The unusual blinking testimony became the heart of the prosecution's case. As prosecutors argued, it was a clear, voluntary identification made by a dying man who knew he had little time left. Woods' defense team tried to cast doubt, saying the blinks were unreliable and influenced by Chandler's medication and condition. But the jury sided with the prosecution, believing Chandler's final message from his deathbed spoke louder than any words could. Ricardo Woods was found guilty of murder and sentenced to 36 years to life, convicted by the silent but powerful testimony of his victim's eyes. In December 2011, a tragic altercation unfolded inside the One-Way Farm Group home in Fairfield Township, Ohio. Lance Tiernan and Anthony Parker got into a dispute that turned deadly when Tiernan violently attacked Parker. Although Parker initially seemed able to walk away, he later collapsed and died from the injuries, with the coroner ruling his death a homicide. In the months that followed, Lance Tiernan appeared before Butler County Juvenile Court, where video evidence of the attack convinced Judge Ronald Kraft that there was enough probable cause to try him as an adult.
And using his right hand and arm in a blow fashion that the court will see and is best described as as I said, a blow type strike, came down with tremendous force once again on the head of Anthony Parker.
This was not at One-Way Farm because of any prior criminal history or any problems that he had with the criminal justice system. He simply didn't have a family that would take him in.
Tiernan's bond was set at $1 million, and a grand jury indicted him for murder. He pleaded not guilty, but ultimately stood trial in mid-2012. Although the jury acquitted him of murder, they found him guilty of involuntary manslaughter. He received a short jail sentence, probation, and community service, and the case returned to juvenile court for final sentencing under Ohio law. In December, a deadly confrontation outside the Grub Pub in Hamilton ended the life of Donald Holland, a well-known youth football coach admired in his community. That night, Holland and 55-year-old Myron Lamar Doby nicknamed Cowboy, got into an argument that turned violent. Witnesses described how tensions between the two men escalated after an earlier dispute at another bar. Outside the grub pub, Dooley pulled a weapon and shot Holland, leaving the local community stunned and grieving the loss of a mentor to many young players. After turning himself in, Dooley pleaded not guilty and went to trial under Judge Michael Sage. Prosecutors argued he fired at Holland intentionally during their confrontation, while the defense claimed Dooley acted in self-defense against a much larger man. The jury deliberated for about 3 hours before finding Dooley guilty of murder. He was sentenced to 21 years to life in prison with the possibility of parole after 18 years. In June 2007, Sheryl McCafferty shot and killed her husband, Bob McCafferty, in their Fort Thomas, Kentucky home. She claimed she acted out of fear after enduring years of abuse, but prosecutors argued she shot him while he slept, calling it an unjustified killing. In 2009, a jury convicted her of first-degree manslaughter, and she was sentenced to 18 years in prison. When she later went before Kentucky's parole board in 2011, her request for early release was denied, keeping her behind bars as she maintained she acted to protect herself. Years later, McCafferty pushed for a new trial, arguing her original lawyers mishandled her defense by failing to fully explore and present a battered spouse claim. Her former attorney, Frank Mungo, testified that the defense team chose not to pursue that angle because the battered woman defense rarely succeeds in Kentucky and lacked witness support in her case. Despite her insistence that her story wasn't fully told, a judge ruled there was no proof her lawyers had failed her. McCafferty's appeal ended there until 2015, when outgoing Kentucky Governor Steve Beshear granted her a pardon, restoring her civil rights and closing a long, painful chapter for both her and her husband's family. In the early morning of November 13th, 2022, 4 University of Idaho students, Madison Mogan, Kaylee Goncalves, Zana Kernodle, and Ethan Chapin, were found brutally stabbed to death in their off-campus rental home in Moscow, Idaho. The attack, which occurred between 4 a.m. and 4:25 a.m., left 2 other roommates unharmed but traumatized. The violent nature of the crime shocked the quiet college town and drew national media attention. Nearly 7 weeks later, on December 30th, 2022, police arrested Brian Christopher Kohberger, a 28-year-old criminology PhD student at Washington State University. He was taken into custody at his parents' home in Pennsylvania. Investigators tied Kohberger to the crime through DNA recovered from a knife sheath found at the scene, along with cell phone tracking data and surveillance footage placing him near the home around the time of the murders. In May 2023, a Latta County grand jury indicted Kohberger on 4 counts of first-degree murder and 1 count of burglary. By June, prosecutors announced their intention to seek the penalty, citing the horrific and calculated nature of the crime. Due to the overwhelming media coverage and potential bias among local jurors, Judge Stephen Hippler approved a change of venue in September 2024. The trial was moved from Latta County to Ada County in Boise, with jury selection expected to begin in August 2025. However, in June 2025, Kohberger's defense team, led by Ann Taylor, filed a motion to delay the trial.
Your Honor, our motion to continue has been filed and is necessary to protect Brian Kohberger's rights under the United States Constitution and the Constitution of the State of Idaho. Specifically, a continuance is necessary to protect his due process rights, his rights to a fair trial, his rights to effective assistance of counsel, rights to confrontation, Mr. Kohberger's right to present a full defense, and if it should come to it, a fair sentencing hearing and to be free of cruel and unusual punishment. The record of this case spans 2.5 years, and it shows that this request does not come as a surprise. Looking through the history of this case shows that the defense has met challenges and difficulties along the way, but has been dedicated in meeting all of the deadlines. We have talked about the discovery issues in this courtroom before, and that in large part brings us to need a continuance. 68 terabytes of information is a huge amount of information. There have been 23 requests for additional discovery over the span of 2.5 years, and 7 motions to compel. When I say that this doesn't come as a surprise, that this comes from the record, I would direct the court to look back to May of 2023 and June of 2023, and our second motion to compel. Included in that was what was known as Exhibit A from the defense, and that depicted how we were receiving discovery. So this is not a new issue. This is something that's been coming up for a long time. We were receiving discovery, but it was such that you would get a file that would say hundreds of photographs, hundreds of pages of reports, each having to be looked at individually to know what was there and then organized. This case has also faced unique issues, starting with the media coverage of this high-profile case, non-dissemination orders that were addressed in courts, and then the grand jury materials that we had to fight to get access to before we could properly challenge the grand jury indictment. We faced issues with discovery, particularly with the IGG materials. We spent a great deal of time trying to get access to those materials. Those were ultimately what we could get, was ultimately presented in a motion to suppress, and that's preserved should there be a conviction in this case. We faced venue issues in this case, culminating in the change of venue and bringing us to Ada County. At the first hearing in this courtroom, we discussed the discovery issues and not having read everything and being ready with a full investigation in this case. That was apparent through our motions to strike penalty, our motions to compel expert disclosures filed in September and December of 2024, and requests for more time to file our motions in limine that was granted in January of 2025. Throughout the course of the motions in limine and then a motion to strike death based on discovery issues in February and March of this year, the record is replete with notice that we are not prepared to go to trial in this case. The discovery is vast and we have not had a chance to review it all. That we met deadlines for experts shows our dedication to comply with court orders. It does not depict effective counsel ready to go to trial on this case. We would submit that it's the court's responsibility to assess this motion to continue with heightened due process that's required in penalty cases. Penalty case is different. That comes from Ford versus Wainwright at 477 U.S. 399 at 411. The court must be sensitive to safeguard every avenue of due process. The Idaho Supreme Court said the qualitative difference between and other penalties calls for a greater degree of reliability when is imposed, and that comes from State versus Creech, 105 Idaho 362 at 383. Looking at all of the constitutional rights Mr. Kohberger has, effective assistance of counsel really becomes the crux of how all of these other rights are covered for Mr. Kohberger. An effective assistance of counsel applies both to the merits phase and the penalty phase of a penalty case. The courts are guided and counsel's guided by the American Bar Association guidelines on capital cases. Wiggins versus Smith, 539 U.S. 510 at 524, said the ABA guidelines are guides to determine what is reasonable, and that's talking about reasonable performance by defense counsel in a capital case. The Ninth Circuit in Andrews versus Davis at 944 F3D 1092 at 1109 relies on the ABA guidelines as the proper measure to test an attorney's investigation. In Idaho, our public defender statutes reference the ABA guidelines as applying to indigent defense. These apply to the full investigation of the merits phase and require us to raise all legal claims. They require us to perform a background on all witnesses that might be called, especially those being called by the state. That means that we have to review all discovery to be able to present a full defense for Mr. Kohberger. We cannot present what we are not aware of. I would note for the court that discovery has been ongoing. I received discovery just this week. It is discovery that I have not reviewed yet. Considering what's required at a penalty phase in a capital case, we're required to perform in a way that the jury can carry out their function of individualized sentencing.
That means that Mr. Kohberger's background has to be known and investigated and ready to present to the jurors. Evidence of his character has to be known and ready to present to the jurors, and his circumstances have to be known and ready to present to the jurors. That's addressed in the Woodson case and in the Lockett case. The jury must have the opportunity to consider all evidence that may weigh against the death penalty, and that means anything from his life history. It is the duty of the defense to find and investigate all mitigating information.
They argued that the volume of discovery, 68 terabytes of digital evidence combined with ongoing publicity, hampered their ability to provide effective counsel. They raised concerns about the fairness of the proceedings, citing constitutional protections in capital cases and referencing legal precedents such as Ford versus Wainwright and State Vrier's Creech. They also pointed to obstacles in gathering medical records and conducting sensitive interviews for the penalty phase, especially with several uncooperative witnesses. The prosecution opposed the motion, arguing the defense was already well prepared. They had named 55 mitigation witnesses and submitted over 130 exhibits. Prosecutors claimed the defense's concerns were too vague and lacked concrete justification. Judge Hippler ultimately denied the defense's request in late June 2025. He ruled that while the media environment was challenging, it didn't justify delaying the proceedings.
The state submits that the evidence that I've given just a quick overview of and that to present in court would consume weeks, which the state is prepared to do and has been prepared to do, would show that as the defendant has just admitted and pleaded guilty on November 13th, 2022, Ms. Kohberger entered the residence at 1122 King Road in Moscow, Idaho. He did that with the intent to. We will not represent that he intended to commit all of the murders that he did that night, but we know that that is what resulted, and that he then killed intentionally, willfully, deliberately, with premeditation, and with malice forethought, Manny Mogan, Kaylee Gonzalez, Ethan Chapin, and Santa Cruz. Thank you.
Thank you. All right, based on the state's proffer and importantly based upon defendant's explicit admission to committing these crimes, the court finds there is a factual basis. Therefore, with respect to count 1, burglary, felony, how do you plead, Mr. Kohberger, guilty or not guilty?
Guilty.
As to count 2, murder in the first degree, as it relates to the murder of Madison Mogan, how do you plead, guilty or not guilty?
Guilty.
As to count 3, as it relates to murder in the first degree for the murder of Kaylee Gonzalez, how do you plead, guilty or not guilty?
Guilty.
As to count 4, the first degree murder of Xana Kernodle, a human being, how do you plead, guilty or not guilty?
Guilty.
As to count 5, the first degree murder of Ethan Chapin, a human being, how do you plead, guilty or not guilty?
Guilty.
Right. The court will find that the defendant understands the nature of the charges and each offense and the possible consequences to him of his guilty plea. The court finds that there is a factual basis for the plea and finds the defendant believes the plea to be in his best interest. I find that the plea was given freely, voluntarily, and was intelligently made. I accept the plea. I direct that it be entered. I'll continue the matter for sentencing in this case.
On July 2nd, 2025, Kohberger entered a guilty plea to all charges in exchange for avoiding the death penalty. Under the agreement, he was sentenced to 4 consecutive life terms plus 10 years with no possibility of parole or appeal. By mid-July, Judge Hippler lifted a long-standing gag order, allowing public statements from those involved. While some concerns about media influence persisted, preparations moved forward. On July 23rd, 2025, the sentencing hearing officially began in Boise. Families of the victims were given the opportunity to speak in court, sharing their grief and calling for justice. Prosecutors also sought to enforce a 99-year no-contact order to prevent Kohberger from reaching out to victims' families. On the night of June 25th, 2025, a quiet neighborhood in Chardon, Ohio, was shaken by a shootout. Just after 9 p.m., police were called to a home on Irma Drive, where they found 37-year-old Alexandria Kurzinger fatally shot in the doorway. She had recently divorced her ex-husband, Stephen Kurzinger, who quickly became the prime suspect. A witness reported seeing a gray or silver vehicle leaving the scene, matching the description of Kurzinger's car. Later that evening, Lake County deputies located him in Concord Township. Inside his vehicle, they discovered a suspected weapon, and according to investigators, Kurzinger allegedly confessed to a bystander. GPS evidence also reportedly placed him at the scene around the time of the shooting. 2 days later, on June 27th, Stephen Kurzinger appeared virtually in Chardon Municipal Court for his initial arraignment. He faced a charge of murder, an unclassified felony in Ohio that carries a possible sentence of 15 years to life in prison. Prosecutors requested a $5 million cash bond, pointing to the firearm recovery, the alleged confession, GPS data, and the fact that Kurzinger had previously failed to appear in a separate misdemeanor case where he was already under court orders not to possess weapons.
Factors here, the state is requesting a $5 million cash or surety bond. And again, looking at the factors, the court is to consider the nature and circumstances of the crime charged, and whether the defendant used or had access to a weapon, the weight of the evidence against the defendant, and the state would inform the court that a witness identified a car matching the defendant's vehicle leaving the scene after the shooting. The defendant was found with a suspected murder weapon in his vehicle. The defendant confessed to a third party that he had committed the offense. There is GPS evidence placing the defendant at the scene of the crime. And he did utilize a firearm to commit this offense. So looking at those factors, they weigh heavily in favor of the state and a high bond. Additionally, another factor is whether the defendant is on probation, a community control sanction, parole, post-release control, court protection order. And at the time of this offense, the defendant did have a pending misdemeanor case in Painesville Municipal Court. He failed to appear for a hearing on June 24th. A warrant was issued, and there was a bond condition in that case that he have no weapons or firearms, so he was violating bond in that matter. Additionally, the court is to consider any considerations required under the Ohio Constitution, and primarily there is the community safety aspect of this. So that is the basis for the state's bond request. In addition to the $5 million cash or surety bond, the state would also ask for the standard conditions, a GPS if you were to make a bond, and no contact with the victim's children, who are also his children.
All biological children?
Correct, Your Honor. Thank you.
Kurzinger's defense attorney argued for a lower bond, citing his lack of prior felony convictions.
Thank you, Your Honor. Considering that the main purpose of bond is to ensure the appearance of my client in any further hearing, I would ask the court to consider a reasonable cash bond, as Mr. Flace pointed out. He has no prior criminal convictions. I understand that there's a pending misdemeanor that's pending. He is a lifelong resident of Northeast Ohio. He has deep ties to the community, including his parents, who live in Lake County. He does have 5 children between the ages of 9 to 16. Obviously, he understands that there would be a no contact order with them. He is not in possession of a passport. Should this court set a reasonable bond, I don't believe he's at risk to not appear.
Judge Terry Stupica, however, sided with the prosecution.
Is concerned with the community safety, of course. Also, he doesn't appear for a misdemeanor. The court's very concerned about that. And he can't comply with conditions of bond, to wit, no firearms. The court is going to accept the recommendation of a $5 million cash or surety bond. Conditions of bond as follows: obey all local, state, and federal laws and ordinances and regulations of this court. Not permanently leave the state of Ohio without court permission. Always keep the court apprised of your current address, phone number, place of employment, and if you're temporarily going out of state. You will not consume alcohol or possess, use, purchase, control any narcotic, drug, mind-altering substance, or any other controlled substance, nor any instrument, device, or other object used for the preparation or administration of drugs unless lawfully prescribed by a licensed physician. You will submit your random breath, urine, or blood test for the presence of drugs and or alcohol. No bars, period. No contact with the alleged victim's children. Is he undergoing any assessments or required to, Ms. Stevenson, that you're aware of?
Not that I'm aware of, Judge.
At this point, I don't think it's...
The state's not requesting
Yeah,
any
I'm not
other.
able to get it right. You will not purchase, possess, own, use, or control any firearms, ammunition, dangerous ordnance, or weapons, including chemical agents, electronic devices used to immobilize, pyrotechnics, and/or explosive devices. Should someone postpone on your behalf, you would be outfitted with a GPS prior to your release, days to be determined. No further alleged acts of violence or aggression. Again, no contact with the alleged victim's children or their place of employment or anyone who holds them in local rentals. Anything else on behalf of the state?
No, thank you, Your Honor.
No, Your Honor, thank you.
Thank you. We've sent down your bond conditions, your bond paperwork, and the preliminary hearing, I believe, at 1:30.
No, 7th, I had July 7th.
July 7th at 1:30.
Oh, 7th, I'm sorry, 1:30, yes, the 7th, 1:30.
Citing community safety concerns and Kurzinger's prior noncompliance with court orders, she set bond at $5 million cash and imposed strict conditions. On July 7, 2025, Kurzinger waived his preliminary hearing, and the case was formally transferred to the Geauga County Court of Common Pleas. 11 days later, on July 18, prosecutors began preparing to present the case to a grand jury, seeking an indictment for aggravated murder, a charge that could carry even more severe penalties. As of now, Stephen Kurzinger remains in custody under high security bond as legal proceedings continue to unfold. In early 2025, investigators began looking into troubling allegations of sexual assault involving Paul Downey, a veteran sergeant with the Boston Police Department. The case began when a boy came forward, prompting authorities to launch a full investigation. The boy participated in a forensic interview, during which he described two incidents, one in March and another in May. He provided details about the vehicle involved, a black Chrysler 300, and shared screenshots from conversations that supported his claims. These messages allegedly showed discussions about money in exchange for meeting up. Investigators used this digital evidence as a foundation. The screenshots, which included partial license plate details, led authorities to track the vehicle to Downey's home and his workplace at Boston Police Headquarters. Surveillance footage from South Bay Plaza aligned with the boy's account of one meeting, showing the Chrysler arriving and leaving within the time frame the boy described to a friend via text. Further, the account used in those conversations was linked to Downey's IP address and phone number. The boy later identified Downey from a photo lineup with a high level of certainty. With this combination of digital trails, vehicle surveillance, and first-hand identification, prosecutors moved forward. Downey was arrested and charged with multiple felony counts, including aggravated offenses and electronic enticement. Each charge carries a mandatory minimum sentence of 10 years if convicted.
All right. Good morning, Attorney Campbell. Attorney Diavolo. Good morning, Mr. Downey.
Good morning, Your Honor.
Attorney Campbell. He was arraigned yesterday. However, I wanted to give you the opportunity if you wanted the reading or not.
I would waive the formal reading.
All right.
As the plea of not guilty under.
Thank you. All right.
Recognizing the severity of the allegations that are before the court today, and recognizing the Commonwealth's request, the primary purpose of bail is to ensure Mr. Downey's reappearance in court. And he has no record, there's no indication that he otherwise would not come to court. $250 is far outside of the realm of what he can post. What I would ask Your Honor to do is impose no more than a $40,000 cash bail, as that is the upper limit of what his family could post. I think with respect to Mr. Downey and his family, he does have some family in the audience today. He does live with his 25-year-old full-time. He is a high school graduate. He's a military veteran of the Marine Corps. Obviously, as Your Honor knows, he was a member of the Boston Police for 30-plus years, obviously attended the academy as a result of that. He's been in Boston his entire life, has several cousins and other family members here. He is not a risk of flight. He has been, and all accounts suggest that he has been nothing but compliant and cordial with not only his arrest, but also today as he has been here. With respect to, obviously the allegations are serious. We are not making a probable cause objection at this time, but I would ask Your Honor to impose no more than a $40,000 cash bail, and as I stated, no objection to the proposed conditions of release that the Commonwealth is asking for.
All right, thank you, Attorney Campbell. And are you entering your appearance for bail purposes only?
For bail purposes only, please, Your Honor. Thank you.
At his June 30th arraignment, Downey pleaded not guilty. His defense team argued that he had no prior criminal record, strong community ties, and had cooperated with authorities. They requested bail be set at $40,000, citing financial limitations.
The Commonwealth believes that a $250,000 cash bail is necessary here to ensure the defendant's return to court. I would point out first the defendant's resources. I believe through the public records database, he made up close to $280,000 last year. The other thing I would like to point out to Your Honor is he is facing 4 charges right now that contain 10-year mandatory minimum state prison sentences. Pointing to the facts of the case as well, I would also point out to the strengths of the Commonwealth's case. So here, Mr. Downey is charged with an aggravated child. It's the same child both on March 26th and on May 11th. Mr. Downey is alleged to have the utilizing his finger on the first offense and then utilizing his also on the first offense. And then on the second offense, which was the May 11th offense, he's alleged to have had the child perform him and then the child again with his the Commonwealth's evidence to lead to the identification of Mr. Downey started with a forensic interview of that child. Through that forensic interview, the Commonwealth was able to collect screenshots from Snapchat for the communications that the Commonwealth alleges was Mr. Downey, where they are negotiating a price. Says to the individual who's asking for the price of $50 again, which is in reference to the March 26th incident. Essentially says that's too low. I'm young, and you're asking me to commit a crime. And the defendant responds with, how about 80? The process of the identification, as well as the juvenile, also provided us with a partial plate of the vehicle, a description of the suspect, and a description of the vehicle that was utilized. We also had text message communications with the juvenile's friend, who he was having a sleepover with that night, that provided us a very detailed window of when he was picked up by the defendant and when he was dropped off by the defendant. Utilizing that information, we were able to collect video surveillance from the South Bay Mall off an apartment building that's facing a parking lot area that was described by that juvenile. A black Chrysler 300 is observed in the video, lining up with the drive time of when the text message from the juvenile was sent to his friend saying he's here. It was approximately a 1-minute drive, and the vehicle utilized the path that Google Maps recommends. The vehicle remains parked for a period of 10 minutes. At that point is when the Commonwealth is alleging the child occurred, and the vehicle left at approximately 1:04 a.m. from that South Bay Plaza Mall, driving along a different roadway than it approached, which again follows the path of travel from Google Maps. And Google Maps refers to about a 2-minute drive time, and the child reached out to his friend at approximately 1:07 a.m., indicating that he was dropped off. We were able to issue to Snapchat for the username from the Snapchat conversations. With that username and that information that we received from Snapchat themselves, we were able to get IP logs. Those IP logs provided the defendants an IP address that was found to be associated with the defendant through further subpoena Comcast. There were also IP logs from Snapchat that show a static IP address from the city of Boston. Further into the investigation, once we learned the defendant's identity from that, we did a cursory look of the address of the defendant's house, and in front of his house, parked perpendicular to the house, is a Chrysler 300 vehicle that's black and has black tinted windows, which matches the description of the child. We initially did a partial plate query with no results. Once we learned that Mr. Downey was a member of the Boston Police Department and actively working at Boston Police Headquarters, the Massachusetts State Police went and did a canvass of the area, of the different parking areas for Boston Police HQ, found a vehicle matching the description that was missing the first digit and was 1 digit off on the plate from what the juvenile provided. That license plate came back again to Mr. Paul Downey with the same address that was used from the records that were received from Comcast. The same phone number that was on Snapchat was also associated with Comcast, and the phone that was recovered off of Mr. Downey also had that same phone number, the phone being what was recovered at the time of arrest. Lastly, as the last step, we did a photo array with the juvenile in question on Friday, and the juvenile initially made a positive ID with a 90% certainty of that identity. The positive ID was a licensed R&B photo of Paul Downey. So with the evidence that's pushed against Mr. Downey, understanding he has no record, he is facing severe penalties with 4 different counts that contain 10-year mandatory minimum sentences. The evidence that we have and the strengths of the Commonwealth's case, as well as his financial resources, the Commonwealth does suggest to this court that a $250,000 cash bail is necessary to ensure his return to court. And relating to the pretrial conditions of release, the Commonwealth would suggest those conditions of release are necessary to ensure the safety of the victim and any potential future victims.
All right, you said you passed those up already?
Yes.
Madam Clerk, do you have those? Madam Clerk? Do you have those conditions of release? Have you had a chance to look at the proposed conditions?
And for the record, there is no objection to the proposed conditions of release that the Commonwealth is requesting.
Okay.
Prosecutors pointed to the serious nature of the charges, the amount of evidence collected, and Downey's access to resources, suggesting he could be a flight risk. On July 1st, Judge Jonathan Tynes agreed with the prosecution and ordered Downey held on $250,000 cash bail.
All right, thank you both. I do find that the serious nature of the charges that Mr. Downey faces, as well as the potential penalties on all of these, on the multiple counts, and his financial resources do pose a risk of flight. So the bill will be set in the amount of $250,000 cash, and the Commonwealth's requested conditions will be imposed. What date for probable cause, Attorney Campbell? And understanding you won't be appearing, if you could just pick a date.
Your Honor, if I could request July 29th, please.
July 29th.
Thank you.
All right, and do you know if Mr. Downey's family has had a chance to reach out to potential counsel?
In my conversations with the Commonwealth, it does appear that there is one attorney that they have spoken with. I intend to reach out to them, but I otherwise have no confirmation.
Okay, all right, thank you.
In Your Honor, the Commonwealth also yesterday filed motion to impound or redact confidential information and motion to restrict distribution of electronic audio and visual recordings. I'd ask that those be allowed without prejudice. Main basis, if he doesn't retain counsel between now and the probable cause date, I'd be turning over a lot of discovery, so I would ask that those be in place.
Cal, it's a different one. It's different from this one.
Your Honor, to that end, I would just ask that it be without prejudice or no action taken on those motions until his attorney is appointed and retained.
Okay. And this is for the distribution of electronic and audio-visual recordings.
That, and then there's also a motion to impound or redact confidential information.
Okay, all right.
He also imposed strict pretrial conditions, including GPS monitoring, home confinement, and an exclusion zone to protect the alleged victim. In response to the charges, the Peace Officer Standards and Training Commission revoked Downey's police certification, and the Boston Police Department placed him on administrative leave. A probable cause hearing is scheduled for July 29, 2025, where more details about the evidence and charges will likely be presented. If Downey posts bail before that date, the court has made it clear that any new charges could result in him being held without bail for up to 90 days. The defendant appeared before Judge Middleton, who was accompanied by probation officer and public defender. The defendant had been arrested due to a bench warrant for failing to appear at a probation violation hearing. The original charges stemmed from an incident with the defendant's grandmother in 2023. The defendant had pled guilty to the charge and was placed on probation under a program aimed at addressing domestic issues. As part of the agreement, the defendant was required to attend anger management classes, refrain from drugs and alcohol, submit to drug tests, and pay fines. If these conditions were met, the charge could be removed from the defendant's record.
The original complaint alleged that on or about January 7th, almost a year ago, that you assaulted your grandmother, Gloria Lee, someone you were residing with in Colon Township. Mr. John Bush was appointed to represent you, and you ended up pleading guilty to that charge on February 21st. You were put on probation under the Domestic Violence Deferral Program, and if you successfully completed the probation, the charge could be taken off your record. I gave you 12 days in jail credit 2 and deferred 10 of the days. I gave you fines and costs. I ordered that you complete the Women's Anger Management Program, no drugs and no alcohol, and test as directed. And the matter would be deferred. Your probation officer updated me through the spring and into the summer about how this was going, and it wasn't going very well. He filed a probation violation petition in September requiring you to be here on October 9th. He alleged that you'd failed to report on a monthly basis, failed to pay fines and costs as directed, failed to abstain from the use of drugs and alcohol or test, and failed to participate in the treatment program, which was the most important part of the probation. Eventually, you just stopped reporting.
However, the probation did not go well. By the spring and summer, the defendant had not been reporting regularly, had not paid the required fines, and had failed to comply with the treatment program. The probation officer repeatedly tried to make contact, but the defendant did not follow through. Eventually, the probation officer filed a petition in September 2024, citing these failures. The defendant missed a scheduled court appearance on October 9th, leading to the bench warrant for arrest.
Yeah, my CPS case was supposed to close Thanksgiving, and we weren't able to stay where we were, so they took my son to CPS.
And then somebody realized there was an open warrant for your arrest?
Yeah.
What day did you get arrested?
Yesterday.
Do you have a place to live?
That's actually the funny part. Is right now, my place to live was at my grandmother's before we came to the DHS.
So you were back staying with your grandma?
Yeah. And I was just gonna get my own apartment in 2 days, Your Honor.
When the defendant was arrested the night before the hearing, they explained that they had been detained at the DHS office after their son was placed in CPS custody. The defendant had been struggling with housing, and CPS intervened when they couldn't provide a stable environment. They had been staying with their grandmother, but had planned to find an apartment soon.
I would like to admit it and say I'm sorry for losing contact. I would like to say I kind of forgot about this whole thing after my grandma and I started getting along, and I had my son in July.
Despite these personal challenges, the defendant admitted that they had not followed the probation rules and acknowledged their mistakes. The defendant's lawyer was not present due to the sudden arrest, so Ms. Jackson was appointed to ensure the defendant's rights were protected. The judge asked the defendant if they wanted to proceed with a hearing or admit the violation. The defendant chose to admit the violation, explaining that they had forgotten about the probation requirements during their family struggles and responsibilities as a parent. The judge listened carefully, understanding the difficulties the defendant faced, but also stressing the importance of adhering to the law.
Do you understand that you have a right to have a hearing and an attorney, and I could have Mr. Bush or other attorney with you? If you admit this violation, I'm going to do the sentencing, and it's likely I'm going to revoke your probation and give you the 10 days that Mr. Frazine recommended. which I originally had set up when I deferred it. So you don't have to admit it, but you have a right to do that if you wish to. If you wish to have the hearing, I can set one up as soon as I can get Mr. Bush available. So do you still wish to admit that you violated the probation?
Yes, Your Honor.
All right. Anybody threaten you to get you to do that
No,
or promise you anything?
no,
Well, as a practical matter, this wouldn't be very hard to prove. You didn't show up, you didn't go to treatment, you didn't contact your probation agent. I don't know whether you were using drugs or not. I hope you weren't, for the sake of your son. Then we had a hearing in October and you didn't show up for the hearing. What's your plan when you get out? Go back to your grandma's?
go straight to my grandmother's and see if I'm still able to get the help from Keystone to there, because Keystone is helping me and my fiance get into Gateway and Sturgis. It's apartments.
Who's your fiance?
Timothy Edinger.
All right, he was here when this went down. Is he the father of the child?
Yes, Your Honor.
I remember feeling very sad about this at the time.
In light of the defendant's situation, including their struggles with housing and family matters, the judge waived the fines and costs that had been imposed. The defendant was granted credit for the time already served in jail, but the probation was revoked. The judge ruled that the defendant would serve an additional 12 days in jail, although with good behavior, they would likely be released after about a week. While disappointed, the judge noted that the defendant had taken responsibility for their actions. The judge emphasized that the defendant would now have a criminal record due to the probation violation, but hoped that this experience would lead to positive changes. With the probation revoked, the defendant was no longer bound by the original conditions, but was advised to continue working toward a stable and law-abiding life. In the end, the defendant's actions had consequences, but there was also a path forward. The judge expressed hope that the defendant would learn from the experience and find the stability needed to avoid future legal troubles. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.